The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon, everyone, and welcome to this remote argument session of the North Carolina Court of Appeals. I'm Richard Dietz. I'm joined on the panel today by my colleagues, Judge John Airwood and Judge April Wood. We have one case on the calendar for argument this afternoon. That's number 2485, Osborne versus Yadkin Valley Economic Development District et al. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Good afternoon, Your Honors. May it please the court. My name is Kirk Sanders, and along with Josh Dearman from the law firm of Hendrick Bryant, we represent the appellant, Lauren Osborne. This case arises from a matter that occurred in December of 2015, when Lauren was riding a school transportation and she was sexually assaulted 21 times on 2 different trips to and from school. We're here because the school chose to change her transportation from a yellow school bus with an adult safety assistant on board to an unmonitored van. Now let's look at the law. Slade versus New Hanover County says the school has a duty to transport Lauren safely. It also, Slade goes further to say that you look at the student and whether there's an increased or heightened duty. You look at the immaturity, inexperience, or the physical limitations of that student. Well, what we have with Lauren is she's an autistic, 40 IQ, disabled student. She has the maturity of a first grader, and she's 20 years old. So she is riding this unmonitored bus as a 20-year-old female with a first grade maturity and a 40 IQ. So she's vulnerable. Now, we look next to when the school made this choice to change her transportation to this from a monitored bus to an unmonitored van. Was there foreseeability of harm? And Hairston versus Alexander Tank talks about the test of foreseeability is whether some harm, some injury would occur to her because of this decision. Hairston goes further to say that this is, you don't have to foresee it in the exact precise harm, but it also can't be so remote or so unlikely. Now let's look at this. The evidence that has been presented is one, the custom of Stokes County Schools was to transport Lauren on a yellow school bus with an adult safety assistant on board for more than 10 years of the time that she was on the Stokes County Schools before they made this change. So there's custom, policies, procedures that they had historically. The other thing is her education plan. She's in a self-contained classroom. And throughout the school day, when she's on the school campus, she is supervised throughout the day. Supervised throughout the day. In fact, her teacher, when asked, said, her special needs teacher said, the reason is to prevent wandering, to prevent bullying, to prevent being picked on. Now, another reason it's obvious here
Mr. Sanders,
that's perceived.
Did her IEP require monitoring?
That's the issue. Her IEP, there are issues with her IEP. Her special needs teacher, so there's no, to answer your question, there's no specific requirement that she needed monitoring on her IEP, but the evidence shows her special needs teacher testified he didn't know about this decision until the day she first showed up on a van. And he said this decision, he was in charge of that IEP team. When asked, well, who made this choice? He said the decision was, quote, above me, meaning it's someone in the administration above him. So the teacher, special needs teacher for Lauren, should have been part of that team and didn't know anything about it. And in fact,
let me ask you a follow-up question there. So with respect to the claim, the remedies you're seeking, or damages you're seeking related to your client's injuries, is it limited to, so it's ordinarily in a negligence case, you prove a duty of care, you prove breach, and then if there's an injury, you prove that the breach proximately caused that injury. So if the injury would have occurred even without whether the negligence was there, the breach of the duty or not, typically we say that you can't satisfy proximate causation. So just so I'm clear, is the only means of showing causation in your theory here that there needed to be a monitor or some person present in the van in addition to the driver and your client?
The short answer to that question, Your Honor, is yes. Now, there could have been some other options. They could have said, we're going to monitor these video cameras regularly. That's one other option. But the best option is what the school's policies and procedures for as far back as the transportation director can remember, which is these disabled, self-contained students had an adult monitor on board. This is a negligence case. And the question is, in the negligence, was it foreseeable, the extent of this harm? And that's why Nolan versus the Moravian Church is probably the biggest case on point here. And in Nolan, this court they first looked at, well, what kind of victim do we have? Well, they said they had a senior high camper who was 16 years old. So they didn't worry about a heightened duty for her. And then they looked at the camp's policies and procedures during the game where the sexual assault occurred. And they said there were supervisors throughout. It was chaperoned. In fact, camp staff and camp counselors participated in the game. They said they had a buddy system in place. The camp did everything it could to try to protect these students. Whereas here we have the teacher not making the decision. If you're looking at the IEP process, there are 7 different documents from 7 different dates that are supposed to be for the one meeting, the one same meeting. So we contend there was no meeting based on the procedures. First of all, the school nurse testified when asked. She said, if I had been asked whether or not Lauren needed a monitor, I would have said yes. She needed one purely for her diabetic issues, but I wasn't asked. And Lauren was on a monitored throughout the school day for her diabetes by the school nurse, but they didn't ask that. Dr. Bluth, plaintiff's expert, presented evidence based on industry standards. And she said, industry standards show that you have to look at Lauren and every other self-contained student on being transported by the school and decide on a case-by-case, individualized basis whether or not they needed monitoring or not. And the school didn't. And she said that was horrific error.
Mr. Sanders?
I'm sorry. I'm sorry, Judge Wood, go ahead.
Thank you. My question is, was the nurse regularly consulted in other students' IEPs within the school system or not?
From the testimony she gave in a deposition, it appeared the school did not include her in these disabled, self-contained students' IEP team meetings. So no, they didn't. But they should have. I mean, Lauren had medical issues. Lauren could not take care of her medical issues. Again, she had a first grade maturity, a 40 IQ, and she's autistic.
So several times you've mentioned some potential harms that could be prevented through monitoring. So you mentioned your client's diabetes, for example, that can be monitored. You mentioned both avoiding her harming herself inadvertently, but also preventing bullying and things like that. But I think the argument we're going to hear from your friend for the appellee is that none of these things are like being criminally attacked in a sexual assault. That breaks that chain because that criminal act is not foreseeable. So, what's going to be a response to that argument, which I think is going to be a big one we're going to hear from the appellee.
And thank you. Let me address that on several notes. But first and foremost, the appellee in their brief never once mentioned the word foreseeable, never once mentioned the word vulnerable. But let's talk about that. Once the school made this breach, once they did not make this decision to continue to monitor per their custom practices and policies, there's an extended, this was the potential injury per Hairston and all that. including the Nolan case, this is a logical ultimate outcome. So the question this court has is, was it foreseeable? The test would be, what was the extent of the duty of the school to safeguard Lauren? And should they have known by doing this, not putting a monitor on board, this might be a likely outcome of some injury? We have testimony that had there been a monitor on board, many of the staff of the school said, had there been a monitor on board, it would have prevented these sexual assaults.
Now, when the school board went to the Yadkin Valley Economic Development District buses or transportation, did any of those forms of transportation have a monitor on them?
I think if I heard you correctly, you're asking, did any of the Yadkin Valley vans for Stokes County have monitors?
Yes.
That's the problem. The answer is no. And let me show you the very first, this shows the foreseeability. The very first question coming back from Yadkin Valley, a private van company, to the transportation director was this. Question 2, do you need monitors on the vans? This means the school's not making this decision process, but a private van company is. Now, within 2 hours, the transportation director, this is their response. Within 2 hours, they say, no monitors are needed with this group. So the van company, now, at the same time, maybe Judge, Your Honor, this is the question you're getting, while they're running these van companies, thank you, Mr. Dearman, while they're running the contract of these unmonitored vans, the school is still using a yellow bus with a safety assistant for some of the other self-contained disabled students. And in fact, there was testimony from the Waivetti transportation director that there are other school systems, particularly Davie County, that choose a monitor when transporting their disabled self-contained students like Lauren. So when Lauren is in school, she's constantly supervised. The custom was that she was transported with the yellow bus before the school decided to change its transportation for cost-saving reasons. And if we'll look right here, this will demonstrate that the school's motivation for changing Lauren's transportation was, and if you look at the very bottom, the email started at the bottom, last line on the right, we are hoping you can eliminate overtime. That's an email to the transportation director. At the top, it says, again, just to reiterate, but a separate email, it would help cut down on the TAs, the teaching assistants, overtime. Can you make it happen? This is why this email happens within weeks before they go and hire Waivetti to transport Lauren and other disabled students. Now, if we look at this in foreseeability, first of all, you look at schools' policies and procedures. You know, James versus Charlotte Meck, this court said, we're going to find no liability because the plaintiff produced no evidence whatsoever. Again, no evidence whatsoever of the school's policies, practices, customs, rules, regulations, laws. The school we produced on their custom of always doing this with a teaching assistant. But their school manual says safety is a top priority in transportation. Safety is paramount. It goes further. 1710 of the policy prohibits bullying, prohibits sexual assaults, and calls disabled children a protected class. This means if you look at the Briggs case, you use a school's rules as their knowledge that they understood that there was a danger. They understand there's a danger to Lauren. Again, she's supervised and her teacher testified to prevent wandering, bullying, picked on. She's supervised all day at school. But the school changed that for Lauren when they just contracted it out to eliminate overtime.
So, counsel, is it your position that the duty of care here means that for every student with special needs who's transported alone in any kind of van or bus, that there must always be a monitor? And if that's not your position, how are we going to craft a rule here that would impose the duty in this case and not impose that duty in every circumstance?
Your Honor, I am not saying that this goes across the board. As plaintiff's expert, Dr. Linda Bluth, who's a nationwide, nationally renowned expert, said it's on a case-by-case basis. And so my suggestion to this court is like in Nolan, they evaluated the victim and said she's a 16-year-old senior high camper, no limitations, no heightened duty. Here, this court has a load of evidence about Lauren and her vulnerability. 40 IQ, autistic. She's got a 20-year-old woman's body, but she's got a first grader's maturity. There is enough evidence that, taken in a light most favorable to the plaintiff, this must go forward to the jury. And that's what this court can tailor this and say it's a case-by-case basis. Again, we look at the general rule. The general rule is intentional torts are not foreseeable. However, if you take the Foster versus Winston New Ventures line of cases, they carve out these exceptions. And this case, Lauren's case, based on all the evidence we have, is an exception because she has got such great vulnerability that the school has a heightened duty. In fact, she's so helpless that in December of 2015, before the sheriff contacts Lauren's mom discovers anal bleeding with Lauren. And Lauren cannot explain to her what happened. She's that helpless. She can't tell her mom what happened to her.
Is there any evidence in the record, as you had indicated, that they used the Yadkin Valley group for some, and they still had the, quote, yellow bus, close quote, for others? Is there any evidence in the record as to how the decision was made as to who were kept on the school system's yellow bus and who were moved to the third-party contractor transportation?
Your Honor, that's an excellent question, and we have no evidence as to how their decision-making occurred. But I will tell you this, the transportation director and the exceptional children's director testified under oath and said, if there's a wheelchair student, there must be a monitor on board to help with the operation of the lift. And we have evidence on the videos that have been submitted to this court. There is a student BL is on there with seizure protocol in a wheelchair. She's severe and profound, but she's on there. Your Honor, we think that the jury should determine that they basically just took certain willy-nilly blanket, moved some students over to this van company to get them home, and did not make any decision as to what was in those students' safety and interest.
Mr. Sanders, did Wyvetti offer the monitors at a cost to the school, or was the arrangement supposed to be that if a monitor was needed, the school was going to provide the monitor for the student?
Excellent question, Your Honor. And based on that emails exchanged back and forth, the very first question, Wyvetti put the question to the school, do you want us to quote this with a bid for a monitor on there? So they were going to say, we're going to supply you a driver, a van, and a monitor. And the school turned them down. And in fact, we have testimony that was done. That monitor, just like the bus driver, would have been a minimum wage job because the bus driver said he made minimum wage. So for $400 a month, the school turned down the option of having a monitor on this van. Now, we talk about vulnerability. There's evidence, and we introduced Sobsey and Doe, which is a study from 30 years ago, which said disabled students, female disabled, are more likely to be sexually assaulted than general population. We introduced Department of Justice statistics, which said they're 3 times more likely than the average population to be sexually abused. Back to the Sobsey and Doe, it even notes that over 5% of all perpetrators of sexual assault on these disabled people are special transportation drivers, like the case in this one. Your Honor, we've talked about the vulnerability, her helplessness. We've talked about her being constantly supervised at school, but they left her off. This is a duty. What is the extent of the duty of the school to safeguard Lauren? This is a negligence case, so foreseeability is a jury issue. The gravamen of this complaint is negligence. Your Honor, we say that if this court lets this summary judgment stand against Lauren, then it's going to give school systems across this state the excuse not to perform the adequate duty to the extent of our most helpless students. Any further questions?
All right, I think we understand your argument. Thank you, Counselor. We'll hear from the appellee.
Thank you, Your Honors. May it please the court, I'm Deborah Stagner with Smith in Raleigh. I'm here on behalf of the Stokes County Board of Education. What happened to Lauren Osborne at the hands of Robert King was tragic. There is no doubt. Robert King violated his duties and responsibilities. He ignored his training. He disregarded the directives of his employer, Yadkin or Yadkin Valley. He even went against his own admitted understanding of right and wrong, and he did that under circumstances where he could fully expect to be caught on camera. Robert King's actions did not occur because the Stokes County Board of Education was careless in contracting with Yadkin to provide transportation services for its disabled students. Robert King's actions did not occur because the school didn't hold enough IEP meetings or invite the right people to participate in those meetings. And Robert King's actions did not occur because the Stokes County Board of Education failed in any legal duty to Lauren. This case occurred.
Ms. Dagner, my question goes back to the same question I asked Mr. Sanders. Is there any evidence in the record as to how the decision was made as to which students were kept on the school system's, quote, yellow bus and which were moved to the Yadkin Valley Transportation Company?
Thank you, Your Honor. Yes, the record is replete with evidence about how that decision was made. The transportation director, Brad Langford, the exceptional children's director, Tracy Royal, both testified that students whose individual education plans did not require a monitor would be eligible to ride on the Yadkin bus without a monitor. The only reason that monitors were on the yellow school buses is because some students had individual education plans that required, under federal law, required them to have a one-on-one monitor with them or an adult assistant with them at all times. So,
who went to which, or agents of your client, the employees of your client made the decision as to who went to the yellow bus and who went to the third-party transportation?
Based on the routing, and to go to Mr. Sanders' point, the school board certainly considered cost. They have to balance their budgets, taxpayer money, just like any government entity. But the decision was made it was prompted, if you'll look in the record, in the minutes of the board meeting and the testimony of Mr. Langford, that decision was prompted because some students were riding the bus for 2-3 hours a day, and it was very hard on those students, as well as being hard on the employees who had to put in that much overtime. So the decision was made, and there's evidence in the record that it was not a cost saving necessarily, it was almost a wash, but the decision was made based on the routing of the student and whether the student's IEP required a monitor. Not every student attended the school in their home district because of specialized programs like Lauren. And so Lauren was not riding the bus that she would have ridden to go to her normal school or her base school because she had this self-contained classroom that was only at West Oaks High School.
So one argument your friend for the appellant is making is that this decision there's a reasonableness component to the question of whether there was a duty owed here, and reasonableness is kind of a quintessential fact question. This is a case-by-case analysis, and so a jury has to hear this evidence and decide under these circumstances should Osborne have had a monitor on that van. So what's your response to that argument that this has these material fact questions that are as part of the analysis?
Well, Your Honor, thank you. I would be happy to find any, identify if Mr. Sanders identified any genuine issues of material fact. In fact, the cases of this court and the Supreme Court say that summary judgment is rarely appropriate in cases of negligence, but not that it is never appropriate. And this court has certainly held that summary judgment is appropriate in a cause of action for negligence where there's no genuine issue of material fact and the plaintiff fails to show one of the elements of negligence. And we contend and have argued that there is no genuine issue of material fact in this case. This is a situation where the standard of care is the ordinary exercise of prudence under the circumstances. I don't believe that it is appropriate or correct to say that there is a heightened standard of care. You look at the standard of care of exercise of reasonable and ordinary prudence under the circumstances.
But
in this case,
a special needs child, you concede that is a factor that has to be considered here, is it not?
Yes, Your Honor. The Payne case said that the amount of care, while the amount of care due to a student increases with the student's immaturity, the standard of care remains the exercise of ordinary prudence under the circumstances. And specifically, the Payne case said there did not create a heightened standard of care. And Your Honor, I would argue, and it has been our position, that the board exercised that ordinary prudence under ordinary care under the circumstances when it contracted with Wyvetti as it is authorized to by statute 115C-253, authorized to enter into contracts to provide special transportation. The district did due diligence in the record. Mr. Lankford's testimony talks about the documents that he reviewed, the interviews that he did to determine that Wyvetti was an appropriate contractor entity to fulfill these duties, fulfill these services for the school district. And so certainly the Board of Education owes a duty to Lauren to exercise ordinary care in its transportation services. What Mr. Sanders...
You just threw a litany of things that your client did in order to make this determination. Is it not a question for the jury as to whether or not those are reasonable under these circumstances?
Well, Your Honor, I would point to the Little versus Omega Meats case, which says that a employer is not liable for the negligence of an independent contractor or for the harm tort by the contractor directly. There is a potential for negligence based on negligent hiring of the independent contractor. So the board does not disagree that it had a duty to act with reasonable care and prudence in selecting that independent contractor to provide services, transportation services to its students, including Lauren. And the trial court below ruled that there was no negligence and there was no proof of negligence in the selection of Wyvetti. There was no evidence that Wyvetti was negligent. There's no evidence that the board did not exercise reasonable care in selecting Wyvetti as an independent contractor. So the plaintiff has not even addressed that argument, and I would contend has abandoned that argument by not arguing that there was any negligence in the selection of Wyvetti as a contractor. So in order for plaintiff to succeed in this appeal, that she has to show that there was some other duty separate and apart from the duty to exercise care in the selection of an independent contractor to provide her transportation services. As Mr. Sanders noted, and as Your Honors have noted, typically there is no liability for the intentional criminal acts of a third party. Plaintiff argues at length in her brief that the board breached its duty to Lauren by not evaluating the change in her transportation from a yellow bus with a safety assistant to contracted transportation without a monitor. And I would submit that this is a red herring. There's no statutory requirement in North Carolina to provide a monitor or a safety assistant on the bus. The General Assembly has left that to the discretion of school superintendents under 115C-245D and E. But plaintiff then points to the procedural requirements and attempts to engraft those procedural requirements of the federal law known as the IDEA onto a common law negligence claim. So instead of looking at ordinary prudence, plaintiff would have this court craft a rule that any student that is has special needs under the federal law, disability law, you have to determine on a case-by-case basis what the needs of that student are in a negligence context. And that law is intended to require the needs, the services and educational programs to ensure a free, appropriate public education. And so plaintiffs would have this court substitute that individualized determination under the federal education law for the standard ordinary prudence of North Carolina's general common law negligence claim. And so Lauren's IEP did not require a monitor on the bus. It didn't require a safety assistant on the bus. And plaintiff has acknowledged that he is not, or that plaintiff's counsel has acknowledged there is no claim under the IDEA, and there couldn't be because it would be barred. But plaintiff's argument is really that a school board is liable under a theory of common law negligence for the failure of an IEP team to comply with the procedural requirements of that federal law intended to ensure educational access. So the crux of plaintiff's argument is that having another adult on the Wyvetti van would have protected Lauren from the criminal assaults of Robert King, which the plaintiff says were foreseeable. Would another adult on that bus have prevented Lauren from being assaulted? It's possible, but plaintiff's own expert testified that she is also aware of reports that monitors themselves have sexually assaulted students on buses. So plaintiffs have not argued that Lauren needed a monitor on the bus. Well, let me rephrase it a different way. The plaintiff's argument is that Lauren needed a monitor on the bus to protect her from the bus driver. There's nothing in the record that says that Lauren was provided with a separate monitor at school to follow her teacher around and ensure that her teacher didn't assault her. The teacher is the person who is providing that supervision. There was a nurse there to monitor Lauren's blood sugar, although there's no evidence that Lauren ever suffered any medical emergency on a school bus. Lauren rode this Wyvetti van. It is undisputed for almost 2 years, from November of 2013 to November of 2015. There was never an issue of bullying, harassment. There was never any concern about her medical care or her having a diabetic issue. Lauren was a student who was like many other students within Stokes County schools and other public schools across this state who had special needs. And there was certainly care taken to ensure that the transportation that was provided to her met all the legal standards of the state of North Carolina, and that she received the services that she was entitled to under her IEP.
Ms. Stagg?
Yes.
I'm sorry, Judge Everwood, go ahead.
Judge Wood, I'll let you, and then I'll.
Thank you. So, Ms. Stagner, my question is, you mentioned that Lauren had rode the bus for 2 years, the Wyvetti bus, but during that 2-year time period, is there any evidence that the videos were ever reviewed other than the one that led to this cause of action?
There is, there was no evidence that the videos were reviewed. There was testimony from both the transportation director of Wyvetti, that they reviewed the videos when there was ever a concern or a need to investigate. The former member of the Department of Public Instruction who oversaw transportation, Derek Graham, who testified in this case as well, said that there was not a practice of routinely reviewing video cameras on buses. There's no requirement to put video cameras on buses. That really the purpose of those when they are on buses is to go back after something has been reported to review it. And Miss Dr. Bluth, plaintiff's expert, testified that, in fact, the mere presence of video cameras on buses and vans was a deterrent to sexual abuse or abuse of students. And she testified that in her experience, there were more cases of abuse 15 years ago than there currently are because there were more videos, and that the mere presence of those cameras was a deterrent.
You mentioned, to follow up briefly on Judge Wood's question, which was part of what mine was, but you mentioned that there had been no evidence over this 2-year term that she had suffered any problems. How long did this sexual abuse occur?
There is only evidence of 2 different days that it occurred in December of 2015. And I don't mean to minimize it by saying only, but there was evidence of multiple assaults over 2 days in 2015, December of 2015.
So the number 21 that I've read about in here occurred in a brief period of time. It was not an extended period of time. Is that?
That is the evidence in the record, Your Honor. So to go back to the undisputed facts, Robert King held the required licenses to drive the Wyvetti van, and prior to his employment, Wyvetti checked his references, his criminal background check, did drug testing. They continued to do quarterly criminal background checks on Robert King after he was hired, and those checks never revealed any reason for concern. He received 40 hours of classroom training and on-the-job training. He was trained to recognize signs and symptoms of diabetes and to call 911 if there was an emergency. He had been trained on appropriate interactions with disabled passengers. He received sensitivity and sexual harassment training. He understood that he was not supposed to touch passengers he was transporting. Robert King knew that there were video cameras on the van and that he was being recorded, and he knew that it was wrong to molest Lauren, but he did it anyway. I think I've covered some of the points that I was going to cover. Obviously, Your Honors are well aware of the test, the 3 things that plaintiff must show, the elements of negligence. This court reviews the summary judgment de novo. The court should affirm if there's any basis for the trial court's ruling. And summary judgment, it would be our position, the board's position, summary judgment was proper in this case in light of the undisputed material facts, and plaintiff's forecast of evidence fails to establish negligence as a matter of law. As I've explained, the rule, the law for the negligence of an independent contractor, and there's no dispute that Wyvetti was an independent contractor of the board, and that Mr. King was an employee of Wyvetti. And so in order to have a direct negligence claim against an employer for the acts, the torts of an independent contractor, there has to be a showing that there was negligence in the hiring. And the trial court below said that there was no negligence in the hiring or retention of the independent contractor. It's clear from this court's precedents, including the Casarano case that was cited by plaintiff, that when there are no disputes as to the facts, the issue of duty, of whether a duty exists, is a question of law for the court. And in North Carolina, the law is well established that the duty owed to a student is ordinary prudence under the circumstances. Lauren's disabilities were part of those circumstances, but they do not create a higher standard of care. The court could end at the analysis of the independent contractor and not go any further, but I do want to address that there was no duty to provide a bus monitor or safety assistant. And I've talked about that there is no duty under North Carolina law, and under federal law, that was a decision of the IEP team. Mr. Sanders wants to argue that the IEP team's federal regulatory duties should be substituted for the judgment in a common law negligence case. There is no law to support that. The question then for this court is whether the board had a duty to transport Lauren on a vehicle with a safety assistant in order to protect her and monitor from harm inflicted by the driver. And I think, as Judge Dietz' initial question was, that does that mean that every school bus in the state has to have a monitor on it to protect students from the potential intentional criminal acts of a bus driver? And I think the answer is yes. If that is how the court rules to reverse this trial court's order in this case, that would be the outcome. If you have a bus driver or a contracted transportation service that has been criminal background checked, that has training, and there is still a conclusion of law that the question of foreseeability depends on the needs of a particular student and whether they are susceptible to sexual assault by that trained, vetted, background checked bus driver, then schools will be bound to have an adult on every bus. And even then, there's no guarantee of protection. As Dr. Bluth said, the attendants themselves can be potential perpetrators. The courts, this court and the Supreme Court in North Carolina have generally declined to impose civil liability for intentional criminal acts that are committed by third persons because they cannot be reasonably foreseen. And the Brown versus Wesleyan University case held that a college could be liable under certain circumstances if the criminal assault was foreseeable. And the foreseeability determined the scope of the college's duty to safeguard its students from those criminal acts. Now, the court in Brown, in looking at the foreseeability question, asked whether there was a repeated course of conduct such as to put the defendant on notice that it was reasonably foreseeable that such an attack might occur. And this court held that there were scattered incidents of crime in the record in and around campus, and that was not sufficient to raise a triable issue as to whether the criminal attack on the plaintiff was reasonably foreseeable. And I would contend that the forecast of evidence in this case shows much less. There's no evidence in the record of any prior misconduct, much less a repeated course of conduct that would have put the board on notice that Lauren might be sexually assaulted by a contracted Wyvetti driver. In order for the plaintiff to avoid the board's motion for summary judgment on her negligence claim, she must have forecast evidence that shows some concrete basis for the board to reasonably anticipate that without a monitor, a disabled student would be abused or harmed by the van driver who was employed by a reputable contractor. Instead of foreseeability, the plaintiff would have this court substitute possibility that in our current day and age, someone could subject a child or a vulnerable adult to sexual molestation. And plaintiff relies on the Boy Scout case from California and the common knowledge of abuse. And I would argue that the Juarez case from California doesn't change the analysis of North Carolina law. First of all, that court applied California law that is not on point with North Carolina's. But even so, that court, the Juarez court's analysis of foreseeability isn't helpful here because the facts in that case are so different and so distinguishable from this case. The Juarez decision involves sexual assault by a former Boy Scout, of a former Boy Scout by an adult leader. And that was well after the epidemic of sexual abuse within Boy Scouts had been exposed. The concern within the ranks of the Boy Scouts was well known, and the Scouts had developed a comprehensive training program to combat that problem. But in the Juarez case, that training program hadn't been implemented. And in fact, many of the tools that the Scouts had touted as effective in preventing abuse had simply been ignored. In contrast, in this case, the plaintiff's forecast of evidence about the foreseeability is a generalized research on a national basis about the likelihood that people with disabilities will be victims of abuse or harassment. That 30-year-old study that Mr. Sanders cited concluded that disabled children are more likely than non-disabled children to be subject to sexual abuse in many different contexts. It includes transportation contexts, but also more frequently family members and acquaintances. But I would argue that the nationwide studies about potential abuse of disabled students across many settings does not provide the necessary evidentiary forecast of foreseeability that this court required in the Brown case. And I would also draw the court's attention to the Robert versus Mars Hill University case, which we submitted as additional authority, where the court held that the plaintiff had not presented evidence of repeated incidents of similar criminal activity involving students that would establish foreseeability. So there's simply no evidence in the record or forecast of evidence that, other than these generalized national studies, that the risk of harm to Lauren riding on a Wyvetti van or any student riding on a Wyvetti van was foreseeable, the criminal conduct of the driver. And again, I mentioned Dr. Bluth's testimony. The video cameras acted as a deterrent to sexual assault of students, and that the incidents had gone down in the past 15 years in her experience. And I would finally add that the Boy Scout case, the Juarez case that the plaintiff relies on, involved a very high-risk activity of adult Scout leaders on overnight camping trips with children. The defendant in the Juarez case was often the only adult sleeping in the same tent as the victim. The foreseeability of harm in that situation is much more readily apparent, and a far cry from the facts in this case, where you have across this state and across the country drivers driving students to and from school in the daytime, day in and day out. And I am not aware of any case that says that when the students are disabled, that there is a duty to put in place a monitor to monitor the behavior of that driver. So in conclusion, I will note that there were also arguments or issues on appeal of Title IX and Section 1983. Unless the court has any questions about those points, I would refer to our brief, the arguments in our brief. And then in conclusion, I would ask this court to affirm the orders of the trial court below on the undisputed facts in the record, establish as a matter of law that the board satisfied its duty to exercise ordinary care by contracting with a reputable established organization to transport disabled students, including Lauren. The court could stop the analysis right there and affirm the trial court, but to the extent that the plaintiff has attempted to identify a separate duty to provide a bus monitor to protect against the potential criminal activity of a bus driver, that claim must be rejected for several reasons. Plaintiff cannot bootstrap a claim of common law negligence from the school's procedural failings and omissions under the IDEA, and the standard owed to students in a negligence case is whether the defendant exercised ordinary prudence under the circumstances, not whether a defendant followed the procedural requirements of federal law. Second, the plaintiff cannot rely on a generalized possibility of harm as a substitute for the evidentiary showing necessary to give rise to a duty of the board to safeguard against specific harm. Mr. Sanders said that it could be any harm that flowed from the failure, but I would disagree and say that in those cases where the harm was from an intentional criminal act, that this court's cases have required that evidentiary showing that there was foreseeability of that type of criminal harm, the Brown and the Mars Hill cases. And finally, the forecast of evidence is undisputed that Wyvetti performed background checks on its drivers, provided drivers with training, prohibited drivers from touching passengers, installed video cameras. Mr. King was aware of those cameras, and under the circumstances, the intentional criminal conduct of Robert King was not foreseeable as a matter of law, and the board cannot be held liable for his conduct. I'll answer any questions. If not, I thank you for your time and would ask the court to affirm the decisions, the orders of the trial court below.
All right, thank you. Any rebuttal?
Yes, Your Honors. I'll try to be brief. I want to answer a couple of the questions that were asked about the school. One, there was a question, how was the decision made which students would ride on which vehicles with monitors? And if co-counsel will present, we think that there's systematic failure. This shows that the school ignores anything as far as putting someone on a monitored vehicle or not. This is one of the students we're going to show in the next picture, but if you look up there, it says the child is in a wheelchair. So and then it says wheelchair lift needed. Does this student IEP state the need for monitoring? And it says yes. In addition to that, it mentions she's on a seizure action plan. Now it says it needs a monitor, but let's go to this photo of the van. This is a photo of the van. In the very back is that student. You can see her around that bar. She's the one in the seizure action plan. She's the one who's in a wheelchair. She's the one who her form says needs a monitor. And yet here she is on the very same van that Lauren's on. And that's Lauren in the red sweatshirt. She's pulling the hood down. She's in terror. This is what she does every time a sexual assault occurs. So that's evidence the school ignores its own forms, and it just puts these people on for routes, for geography, to get them home. That's evidence that goes to the jury. Thank you, Mr. Dearman. I want to address a couple other points. The IEP is not a cause of action. The IEP and the process is evidence of the school's failure to make the proper decision based on Lauren's heightened duty because she's more susceptible to harm. Now, another question we had, Judge Wood, you asked, did the school make the Wyvetti review the videos? There's evidence the school didn't even know these video cameras were on there. Wyvetti put them on because they got a grant. And there's only one reason we're here today. There's only one reason they were reviewed at all. And that's because a good citizen of Stokes County called Wyvetti anonymously and reported erratic driving of one of their vans on one of these secluded country roads. And they stumbled across these assaults because of that call. So no, they weren't required to review them. The school didn't even know they were there. And the last thing we'll look at, Wyvetti, when it responded to the school and said, do you want us to quote this with a monitor? That was an option right then for the school to say, sure, quote it both ways. But they didn't. They responded, no, don't need one, within 2 hours of that email. Your Honor, we presented a lot of evidence, taking a light most favorable to the plaintiff appellant. There are genuine material issues of fact regarding duty, regarding foreseeability, regarding proximate cause. And this summary judgment must be denied. This case needs to go to the jury. Thank you, Your Honor.
All right, thank you, counsel. We'll adjourn. Mr. Soar?
This session of the North Carolina Court of Appeals is now adjourned.
All right, thank you, counsel. You're free to drop off WebEx now anytime.
Thank you, Your Honor.
Thank you, Your Honor. Stay healthy.